So next, I would like to call Mr. Vishal Oza, who is a USA's senior director, and I would like to ask you to speak about the role of digital evidence.
Good afternoon, everybody. I feel like we need a little bit of music in the background, like all is well, all is well. um, I'm going to switch gears, and this is a good transition, talking about too much about technology. Now we're going to talk about the process. Um, what about when we talk about the digital evidence and the forensics, there's equal importance to not just the technology, but how the process will work, the importance of it, and why. Um, and expert testimony when it comes to the judicial systems. I'm not going to claim that I'm the expert in when it comes to the Indian judicial systems, because I grew up in India, then I moved to US. All of my education is in US. All of my experience has been in US. I've traveled around the world in many countries, did data collections, have done forensic testimony both in US and Canada. Have a lot of formal training as well. And just wanted to share my experience, and thanks to Vinayak sir and everybody in the team to invite me to speak. What I'm going to start with is the need of digital forensic expertise in litigation. US compared to India is a much more litigious state, litigious country. Anything you can claim, any kind of disputes, it always goes to litigation. The discovery request goes out for many, many years, and it's not easy to get past the court system or as quickly. So the need for digital forensic expertise is one. These days, anything we touch, anything, even when we are not looking at our phones or computers, it's generating data, and it's multiplying in many different ways. And digital forensics comes in play in almost any kind of investigation, whether it's a civil or criminal. So having a need of an expert who can understand not just the technology, but how the rules may be applied, and being an impartial voice to whatever happened and represent the facts to the judge, it's very, very important. To give some examples, let's say if there is an employment issue or there is a theft of trade secret issue, hiring an independent expert gives a voice to the company that this is not done by somebody in IT who may have some bias against some employees, or there may be CEO or C-suite people are forcing them to do something certain way. Instead, if you are retaining an independent expert, a digital forensic expert, then they can do as by the rule of law, and everything that needs to happen after that. The digital forensic experts would also have the experience that is required for what is expected when the questioning comes from the other expert. So generally in the U.S. court system, if you are a plaintiff's expert, there will be another expert on the defense side as well, who can look at your report, who can look at your findings, and write a rebuttal. Or in a very, very complex situation, even the judge sometimes appoints or uses his own help and appoints an expert to see what may be going on. So mitigating those potential issues ahead of time is very important. And also the courtroom experience is a big plus. As before you qualify to be an expert in the courtroom, you'll be questioned in many different ways about your qualifications, why you are called the expert, what is your education background, how many times you have testified, in what manners, and things like that. So there are a couple of types of expert testimony when it comes to digital forensics. One is testifying in writing, and the other one is testifying orally. In writing, it can be in a declaration format or affidavit format, or as an expert report format. Generally, depending on the type of litigation, you're working with outside counsel. The attorneys are, they would direct you which way they want or which way they prefer. If it's just the expert report, then you note down the process, what you collected, how you analyzed, what tools you used, and if there is an opinion or if there is just a fact base. The declaration and affidavits are more fact-based compared to the expert report. You can have a conclusion, you can have a small, I want to say, based on your experience, this is what you've seen before and this is what you think may have happened. So it really depends on the type of the investigation that's needed. In oral testimony and deposition, that's really when you have an opportunity to talk about the work itself, and the other side, the attorneys and the forensic expert, to ask you almost any kind of questions they can ask and poke holes in your process, try to discredit you, try to make the say things that you wouldn't want, or you wouldn't want to say, or say it otherwise. And especially in the courtroom, in order to get admitted to a courtroom testimony, they'll grill you on the stand and prepare you before ahead of time in many different ways. Just a couple of slides about the U.S. court system. The federal versus state courts. There's a Supreme Court at the very top. Right below it, it would be the Court of Appeals. Right below it would be the U.S. district courts and federal courts. Depending on the type of cases, you start with the state courts and move to the federal court and then Court of Appeals, where a panel of judges might sit and look at the very complex cases. If you're following the news, especially about the FBI raids on Mar-a-Lago and some other places, almost all these courts go through step by step, and there is a process, and there's a forensic experts at every single step. And in that specific case, there is the judge appointed a special master and neutral expert that plays a role as well. Something that can be easily Googled, so I'm not going to spend too much time on it. This one I came up with this morning only. It says karma is real, and so is expert testimony. The reason I say that is your expert testimony, whether it's in writing or oral in the U.S. court system, is discoverable. That means anybody from a month from now or 5 years from now or 10 years from now, that record and what you said in writing or oral testimony will always stay there. So if I opine on something today, and 10 years from now, if I'm testifying on a similar subject, the attorneys can pull up the record and say, well, Mr. Oza, you said something like this 10 years ago. What happened? What's changed? So if you are forced to say something just because your client wanted you to say something, it can come and bite you, eventually. So you have to be really careful about what you say and how you say it. A good testifying expert would know where to stand up and say, no, this is what it is, this is how I'm going to say it, take it or leave it. So it's very, very important. Some other things I wanted to share, especially just based on my experience, is how the messaging is happened. Of course, you as a digital forensic expert, you know the technology, you know the process, but it's as important as how you convey the testimony. The judge is an expert in the legal aspect of things, being a neutral and in a variety of ways, and has controls over what he can or cannot do. But it is very important about how you lay out the facts to the judge or the jury so that they can understand this is exactly what happened, taking out the technology out of the way, but still keep it fact-based and evidence-based. So it is very important. Also, in my experience, the quality over the quantity when it comes to the reports or testimony, the less is more. You want to be as direct as possible, and stick to the facts, not just talk about everything that you may have done, but only what may be important and what are your strong points about the investigation, and not point out a lot of the weaknesses, in other words. Some of the judges that I've worked with and my colleagues I've worked with, in my experience, can get bored very easily if you just keep talking about the technology over and over, or keep repeating the things that they may not want to hear over and over. So sometimes building a goodwill with the judge, especially in the courtroom testimony, is very important. The courtrooms are, the schedules are very much backed up. The trial dates are 12 to 18 months ahead of time. And when it's your turn, all they want to hear you is facts, facts, and facts. And you as an expert, you have the obligation to stick to the facts and move on. So building a relationship with the judge in the courtroom is very important. And it also helps with your credibility as well. The last point I mentioned is recovery and exit. So as an expert, you always want to leave out a little bit of room for a margin of error, right? The attorneys will ask you, is it possible that this could be looked at differently? Yes, it's always possible. But is it probable? Probably not, depending on the circumstances. So you always want to leave the room, like if the technology changes, if the tools you used had some bugs that you find out 2 years later, and you need to correct your testimony, or you need to opine on something that may be similar, you want to leave that room out. So whenever you're writing a report or you're providing the testimony, you don't want to say this is the only way it can happen and not any other way that's possible. So always leave the room for the recovery and exit. Some other things that I wanted to share, if you have time, is when you're selecting a digital forensic expert for testimony work, these are some of the things that to keep in mind. So in the US court systems, on some very large investigations, very high dollar amount cases, law firms tend to hire two types of experts. They both will be digital forensic experts, but one team of experts will only do the actual work. They will collect the data, they'll do the analysis, and they'll present the findings. Then there will be a testifying expert who will only look at the results of the consulting experts and testify about it. And their role will be, this is what I was provided, this is what I think is true, and this is my testimony about it. I'm not sure if it's very common in India or not, but this is one of the key factors. Also, if you are retained by the in-house counsel, the HR team, the chief compliance officer, or are you retained by outside counsel, outside attorneys on behalf of the company? Because the issue of privilege becomes very critical. Any communication in writing or verbal, if you're working directly with outside attorney, becomes privilege and not discoverable. Any communication you do with internal counsel or HR people, then that becomes easily discoverable. So the other side can request those records easily, and you have to produce it. So if you are having any internal discussions about any particular issue, let's say HR issues, then those becomes easily discoverable. Something also to keep in mind is if you're looking for individual experts, sometimes some experts I've seen work as a part-time. They already have a full-time job, maybe something in law enforcement or the government, and then on the part-time they do, because of they have so much experience, they work as a testifying expert. So depending on the commitment that's needed for your case, you definitely want to keep that in mind, whether you need somebody who can spend 20 to 30 hours in a week, for how long, and is it applicable to your case. And the last thing I wanted to share is the overpromise and underdeliver. There are digital forensic experts who will say yes sir or yes ma'am and take on the work and agree to whatever you want them to say. But when it comes to the case itself, it can eventually harm you, because you want to hire the expert who will stand up to the facts and not just say what you want them to say. You don't want to get blindsided by something that the other expert will pick up very quickly, or the judge will say something that may be relevant to the case, and that you are blindsided about it. So it's very important that you retain a digital forensic expert that tells you how things is, even though you may not like it. So I know I talked a lot, so any questions?
I have one.
Yes.
In the U.S. courts, how is the judiciary, how tech savvy is the judiciary?
It is much more tech savvy, I would say, these days compared to even 5 years ago. The judges are becoming more and more active on e-discovery and forensics issues. And more recently, I've seen the judges who, let's say, admits that they are not tech savvy. They would appoint their own digital forensic expert. So just to get to the bottom facts, like to give an example, I worked on an autonomous car driving litigation that was very complex. Both sides have 2, maybe even 3 digital forensic experts on both sides. And the judge is like, what am I going to do, right? So he hired his own expert and team of experts and say which side is giving more facts. Yep. Yep. Thanks, everyone.